convenience, but the back of that card says that they own it. Now, who can think for me? What's a better way to do the exact same thing? Power of attorney, and we're going to be talking about that. You can do that same thing. If you want assistance paying your bills, great. Have them use their power of attorney, because then they have a responsibility to you to use the money for your benefit, and it simply is part of your estate and will be distributed pursuant to your will, not by non-probate transfer. So another trap for the other way. And, you know, a cause, probably one of the number one causes for estate disputes is when that child comes in and the local child decides, yeah, I think Mom did want me to have that money. And the child from out of town goes, wait, and then they accuse each other of all kinds of things. My very first case, a number of you knew Bruce Stout, our dear friend who passed away earlier this year. And I had the pleasure of working with Bruce for 16 years. The very first case he assigned me, I think he laughed the entire time. Anyway, was two ladies. And we represented the executor. And it was an $80,000 estate. And they wasted the entire estate on lawyers. They fought and they alleged, they accused, they were so angry at each other. And so as a, fresh young lawyer, I thought it was always like this. When it was all over, my client came up to me and finally told me what it was all about. She, my client, had been the local child. The out-of-town child came to town, went into the house, and could not find the Bugs Bunny mugs they had as children. And when she could not find them, she told my client, she said, you stole those mugs. Well, my client said, you stole. The lawyers never heard that until it was already over. By the time it got to us, it was allegations of fraud and deception and abuse of their mother. You know what I'm saying? But when you boil it all down, it was insignificant Bugs Bunny mugs. Don't leave a mess for your children. If you are clear and you try to set forth, that one also began with a checking account and jointly held. Anyway, sad. I told Bruce that I said I'm never doing another one of those again. That was an entire waste of. Those are a year of my life I'll never get back. Next important part of a will is the selection. We mentioned that earlier. The selection of the executor. The executor is the person who goes and gets appointed at the courthouse, and they take care of your estate. They garner your assets. They file an appraisement. They pay your debts, they pay any taxes you may have, and then they distribute the assets to those who you set forth in the will. Extremely important person. If you don't have a will, the law allows after 30 days, a spouse has preference, but after 30 days, anybody can be appointed over your estate, including who? A creditor. Great! That's going to go well, don't you think? So, it's extremely important that you have a will, even if you think, I don't have much. You setting forth that executor will at least, even if somebody from your family shows up, you'll at least save them hundreds of dollars, because if you don't waive the bond in a will, the law requires that person go get a bond. Do I have any insurance agents in here? I don't want to step on any toes. But, they have to go to the insurance agent and purchase a bond if you don't have a will. So right there, you've paid for your will by avoiding the bond for your executor. The selection of the executor is important. People ask if it should be a banking institution. It certainly can be. It can be a family member. It can be a trusted advisor. If you have to question whether they should be bonded, that's not the person to pick. This person becomes you at your death, relevant to your assets, okay? So you want somebody trustworthy and is able to fiscally handle that responsibility. Now, certainly, if you have a loved one that isn't the greatest with finances, that's okay, as long as they understand that they can hire trusted advisors, accountants, lawyers, trust departments, who can help them with that process. And I will say, for those of you here in Cabell County, your probate clerks do a great job, and they will help people to the extent they can, short of lending legal advice. They do a good job. Their intent is not to make this a costly adventure for your estate. You might hear a lot of people saying, avoid probate, and that is important in some states. Sorry, ma'am, Ohio is one of those where you'll want to avoid probate because Ohio still has an inheritance tax, at least for now. West Virginia does not. That's different than the estate tax at the federal level we were talking earlier. In West Virginia, probate is really not an onerous task. I mean, you can go over, get appointed, and get your certificate for under $50. You file the appraisement, and then, assuming there's nobody causing you trouble, 90 days later, there's a creditor period. Any creditors have a claim. That's the other thing, by the way. In West Virginia, and a lot of people say, well, everything was jointly held. Why should we even do it? Well, in West Virginia, if you go through probate, if you probate that will and file an appraisement, even if it's all zeros, West Virginia law provides that any creditor who may have a claim against that decedent has 90 days to file their claim. So at least you go through it and you know there won't be a credit card company that can, claim you owed them money 6 months from now, kind of thing. So nice side benefit. Let's talk about, so those are the two main, for everybody in this room. At one point in your life, it was important to have a will because you needed to name the guardian for your minor children. So most of you, it's funny, a lot of people bring in their will and they said, I haven't updated it in a while. Okay, all right, well, let's look at that. Okay, it says here you got a guardian for Frank. How old's Frank? He's 60. Okay, Frank no longer needs a guardian. But since some of you may have children with children or whatever, it is important if you have loved ones who still have minor children under 18, the will is where you put that wish as to if you're gone, who is to watch over them. Extremely important. And the will is where that goes legally. Let's talk, before we move on to the next, I want to talk about your choices in a will. You can leave your assets to anybody you want, except the law requires that you not disinherit your spouse. Okay? So, if you're a single person, you don't have to leave a dime to your children. You can. You have total freedom in who you wish to leave your money to. You can leave it to charity, one or more charities. You can leave it to your neighbor. It's your decision. The only difference is if you're married, the law requires that the law sets forth that you can't disinherit your spouse. And in West Virginia, that's called elective share. Not to get too detailed, but basically, it starts with a 2% percentage when you're year 1 of marriage, and it goes up to 50% by year 15. So after 15 years of marriage, your spouse is entitled to 1/2 of what's called the augmented estate. You add everything she has and everything he has together, divide it by half, and if more than that is in your estate and you didn't get it to your spouse, male or female, then they can elect against your will to receive those funds from whoever you had otherwise disposed of it. So, again, another trap for the unwary. There are some exceptions to that, so if that is an issue, You know, a lot of second marriages, third marriages, whatever, that's a trap for the unwary. If they didn't get a prenuptial or a postnuptial, that accidentally creates a mess. So you need to think about that if that is applicable to your situation. Okay. Any other questions on wills right now? Yes, ma'am.
Are there some situations where co-executors can and is a good idea?
Yeah.
The reason I ask that is because my mother was a widow when my dad married her. She had a son. She wanted him, of course, to keep his father's name. And then mother and dad had 4 children. So my dad, I thought very wisely, named co-executors, one of each of those, so that they both would know what was going on.
Right.
Not that he had a lot. That's just how important it was to him.
Sure. And the choice of executor is a personal decision. In that case, when people are appointed co-executors, most people get concerned that, well, my son lives in Chicago. How's he going to be able to do this? Well, if they've hired, counsel, the only time they ever have to show up is to get appointed, to go over after your will has matured and raise your right hand and get appointed. Everything else can be done by mail. So now they do have to agree, and sometimes that creates some issues. But sometimes disagreement isn't. It is for the better of the estate. If somebody was just blindly heading one direction, it's okay to have a safety valve check. And there's nothing against having multiple executors. Now, some people with 5 children name all 5. That's a mess. I mean, you can't get 5 people to agree on where they want to eat dinner, much less, So, but especially in that kind of situation, it is appropriate. Sometimes, if you know you're going to have a mess, if you know, especially blended families and hurt feelings, and you just know your estate's headed for some difficulty, a lot of people choose to name one of the family or an advisor, and then they jointly name a trust department at a bank to provide a little bit more structure to the situation. Okay. Yes, sir.
I understand several years ago I read where in West Virginia, if you can write out a handwritten will, as long as it's all handwritten, no type or anything like that on it, and you could specify who your executor is going to be without a bond and sign it, you don't have to have no witness or anything like that. Is that still true?
It's true. It's called a holographic will. Probably responsible for more lawyer fees than anything else in West Virginia law, because they always get litigated. Because what happens, I'll tell you, no, it's the second most. The most is those things you can print off the internet, the fill-in-the-blank forms, always results in a lawsuit.